afternoon. My name is Melanie Blackwell, and I'm a Capacity Assessment Policy Analyst with the Office of the Public Guardian and Trustee. I'm pleased to welcome you to this session of the Office of the Public Guardian and Trustee Learning Series for 2016. This webcast is part of the Human Services Learning Series, a joint initiative from the Government of Alberta's Human Services Department. Today's session is focused on the topic of capacity assessment. We will have an opportunity to answer some of your questions at the end of the presentation, so please type them into the conversation area and we will answer them at the end. Once again, thank you for joining today's session. The Office of the Public Guardian and Trustee operate under several different acts, but for the purposes of today's presentation, we'll focus on the Adult Guardianship and Trusteeship Act and the Personal Directives Act. The Adult Guardianship and Trusteeship Act was proclaimed in 2009. It was developed to replace the old Dependent Adults Act. In the new act, capacity was paramount to the determination of a need for a substitute decision maker. Capacity assessment is now measured on a continuum. It is no longer an all or nothing situation. In accordance with the guiding principles of the Adult Guardianship and Trusteeship Act, a capacity assessment program was developed. There's 4 guiding principles in the Adult Guardianship and Trusteeship Act. The first one is that capacity is to be presumed. So it's assumed that the person has capacity until such time as an assessment is done to determine that the person may not have capacity, and the court makes the final decision whether or not a guardian was to be appointed. The second guiding principle is that communication method is not relevant to the determination of capacity. So a person might talk in another language or use sign language or have limited speech, and those are not relevant to the determination of whether or not a person has capacity. The third is that autonomy is to be maintained through the least restrictive and least intrusive and least restrictive measures. So we want to do the thing that's of the easiest and least intrusive for the person. Guardianship and trusteeship are the last resort. The fourth guiding principle is that decisions are to be based on the best interests and how the person would have made that decision if they were capable. So the decisions are always in the best interests of that person, and if they had capacity, how would they have made that decision when they did have capacity? The definition of capacity in the Adult Guardianship and Trusteeship Act is that the person has the ability to understand the information that is relevant to the making of a personal decision and the ability to appreciate the reasonably foreseeable consequences of that decision. So do they understand the information that relates to that decision, and do they understand what will happen if they do or do not make that decision? What would the consequences of that be? This is a graphic of the continuum of decision-making options under the Adult Guardianship and Trusteeship Act. So on the left, they start out having their own capacity, and they're having capacity and can make their own decisions, and works down to the right-hand side where they do not have any capacity and they have either a trustee or a guardian appointed. And along the way, there's varying levels of capacity that the individual might have. For the purposes of the Adult Guardianship and Trusteeship Act, if anyone is ever determined to not have capacity, or if it's suspected that they don't have capacity and may need a substitute decision maker, they require a capacity assessment under law before they can have a guardian or trustee or co-decision maker appointed for them. When an adult or youth is turning 18 and shows signs of something such as a triggering event that may result in the loss of or altered capacity, that may require the appointment of a substitute decision maker. When an application is being made to the court for co-decision making, guardianship, or trusteeship, a capacity assessment is required prior to that application. Who can conduct capacity assessments? Under the Adult Guardianship and Trusteeship Act, only certain professions are allowed to do capacity assessments for the purpose of guardianship or trusteeship or co-decision making. Physicians and psychologists are regulated in the Act to do assessments without any specific training. However, there are 2-day workshops offered for physicians and psychologists to further their knowledge in capacity assessment. Physicians can also receive educational credits for attending one of the 2-day workshops. Certain other professions are designated in the Act as being able to do capacity assessments following completion of a 3-day workshop offered by the Office of the Public Guardian and Trustee and designation by the Minister of Human Services. They must complete the 3-day assessment and complete an exam at the end of complete the 3-day workshop and complete an exam successfully at the end of the workshop, and following that they're designated by the Minister of Human Services. The only 4 professions that are able to take that training are registered social workers, registered occupational therapists, registered nurses, and registered psychiatric nurses. Those assessors must also maintain their competency every 2 years and undergo a competency review. Some of the key things that we look at when we're doing capacity assessments and when we're determining whether or not a person may need a substitute decision maker appointed by the court. Capacity is not a medical diagnosis. Once an assessment is done, that assessor provides an opinion as to whether or not they feel the individual has capacity. It's the court that makes the final decision as to whether or not that person does or does not have capacity and requires a decision maker. A capacity assessment is a last resort and is only to be conducted if a need has been established for an assessment to have been completed. The capacity assessment report that's completed at the end of a capacity assessment becomes part of the court application and is provided to the court to assist them to make their decision. The adult that is being assessed for capacity has several rights. One of the rights is that the adult has a right to refuse to undergo or to continue with an assessment. An adult has the right to have a person present to assist them in feeling comfortable and relaxed. The adult has the right to have the assistance of an interpreter or the use of an assistive device to assist with communication in order for them to fully demonstrate their capacity. It's very important that the capacity assessor explain the rights of the individual to them prior to the assessment. Consent is important as well. It's important to ensure that the individual understands what the assessment is and what it's about and what is going to be happening, and that they have the right to not provide consent to that assessment. If they refuse and the assessor feels that they could be at risk of danger to themselves or to someone else should they not have the assessment, they can be compelled by the court to undergo a capacity assessment. The individual is allowed to have someone else present with them if they feel that it would make them more comfortable. It might be a family member, it might be a staff member from wherever they live. However, that person is to remain quiet during the assessment and not take part. They're merely there for the comfort of the individual, and the assessor can and will ask them to leave if they interfere with the assessment. Capacity assessments are completed generally in 2 stages. The first stage is the pre-assessment phase, where information is gathered to determine whether or not to go forward with a complete capacity assessment interview. This assists in identifying triggers that tell the person if there's been changes in the individual's life, changes to their health, changes to their personal living situation. It helps to determine which domains are to be assessed. There's a medical stability assessment that's important to be done first, that must be done within 3 months prior to the assessment being done. The medical assessment is done to ensure that there are no temporary conditions going on with the individual at the moment that might alter their capacity and their ability to make their decisions. So we want to rule out anything medical prior to them having an assessment. It helps to determine what type of decision maker they may need. They may be able to work with a co-decision maker or they may need a guardian or a trustee. A guardian makes personal decisions and a trustee makes their financial decisions, so they may need one or both of those. Following the pre-assessment phase, there's a capacity interview if it's determined that that's needed. This is conducted by the capacity assessor in the decision-making areas identified as warranting assessment. So if the individual can make their own decisions with regard to where they live, then you would not assess that issue. But if there's triggers that are identified that say that the person may not understand or be able to make their own medical decisions, then medical would be definitely an area that would be assessed. So not every area is necessarily assessed, just the ones that are identified as having triggers that require them. So the pre-assessment phase is to gather holistic history of previous functioning, determines what the values and beliefs of the client were, if possible, or still are, if they're able to say that. It determines what legal documents they may already have written. If they have a personal directive or an enduring power of attorney, they would not require an assessment for guardianship or trusteeship because they would already have chosen their decision maker while they had capacity. There's also an attempt to problem solve and come up with informal supports to determine if the assessment is even necessary. So are there ways that you can solve this person's problems without going to the extreme of having a court-ordered guardianship or trusteeship or co-decision making order? For trusteeship, for example, in managing their finances, there may be an informal trusteeship process available that would work for the person, or they may have family assistance that's already helping them and it wouldn't make it necessary for them to have a trusteeship order. If you find that there's no adequate solutions from the problem solving, you weren't able to come up with any informal way for the person to be able to make their decisions or to have informal assistance to make decisions, then you would go ahead with a capacity interview. You would also determine if the risk to the patient or others is too high. If you don't do a capacity assessment, perhaps they're making risky decisions that are putting their life at risk and also the lives of other people. The court would like to know that you've tried other less intrusive methods that have failed. Is there any methods you've tried that have helped the person solve their problems without going so far as a court order, which would then give authority to the guardian to make decisions for that person? And are the problems, is the appointment of an alternative decision maker going to solve that problem? So will it make any difference to the person and to their decision making if they have a guardian, and are they likely to comply with what the guardian requests of them to do? Sometimes the person isn't going to comply either way, so there may not be any point in going ahead with the guardianship application. Are the problems that the person is having likely to persist or become worse? It may be a medical issue that is progressive and is not going to improve and would then require a guardianship or trusteeship order. Once the capacity assessment report is completed, the assessor writes up a report that becomes part of the court application. So the applicant is the person that is asking for the assessment to be completed. It might be a parent, it might be a spouse or a child or a sibling, and they're the applicant that is going to make application on behalf of the adult for guardianship, trusteeship, or co-decision making. The report would go first to that person. They would be the ones that, if they're paying a fee, would pay for that assessment and would be the ones that would include it with the court application. The adult that is being assessed also gets a copy of the capacity assessment report, and then of course it goes to the court as well as part of the application. The review officer is a member of the staff of the Office of the Public Guardian and Trustee, and they personally serve every person who is having an application made on their behalf. So they also get a copy of the capacity assessment report so they can ensure that the adult that they're speaking to has already seen it as well. The report does not go to family members that request it, and members of the family that are notified by mail of the application also do not get the capacity assessment report. They can obtain it from the applicant or through the court process if they request a hearing to dispute the application. Is there a cost for capacity assessments? Capacity assessors that do assessments as part of a private practice and psychologists may charge a fee for the assessment. The fees are set in regulation. There's a $500 maximum fee for assessment for co-decision making, guardianship, or trusteeship. There's a $700 maximum if the assessment is for both guardianship and trusteeship, so they cannot charge more than that fee. Are there other times that a capacity assessment may be necessary? There are a few under the Adult Guardianship and Trusteeship Act. One of them is called specific decision making. This is a one-time decision that is used only when there is a decision required for placement for an adult into a long-term care facility or a residential facility, or if they need a medical decision and they can't make that decision at the time. Those are the only two types of decisions that can be made under specific decision-making authority. And this is not a court-ordered process, but there is a capacity assessment involvement with it. And if there is a protest to the first assessment, there can be, the family or whoever is protesting can request a more lengthy assessment to be completed. Capacity assessors that do assessments for private practice, as well as physicians and psychologists, can choose to have their contact information on a public roster that is available at the website on your screen. It's www.humanservices.alberta.ca/guardianship-trusteeship. And that will take you to a roster of assessors that have been certified and designated, and it's alphabetical by community. So now we'll talk a little bit about the Personal Directives Act, which is also has a capacity assessment requirement. A personal directive is a legal document that allows you to plan for the future for non-financial decisions such as healthcare, residential placement, should you lose capacity to make those decisions. You are the maker of your personal directive, and you may choose to name one or more agents to make your personal decisions should you lose the capacity to do so. Personal directives allow Albertans to choose for themselves prior to the loss of capacity, so that it helps alleviate the need for a court-appointed decision maker. They help others know what you would like or dislike concerning your care and all matters concerning to your life. Personal directives do not include financial matters. That's an enduring power of attorney, which is under a separate legislation. Instructions that you include on your personal directive are legally binding to everyone that's involved. Personal directives have the same definition of capacity as the Adult Guardianship and Trusteeship Act does. So you must be able to understand the information provided to you regarding a decision and the immediate consequences of what could happen if you choose to make or not make that decision. A personal directive is not in effect when it's written. It only becomes into effect once you've been assessed as having lost your capacity, and then it can be activated. That's done through a declaration of incapacity and can only be done by a physician, a nurse, or a psychologist. There are regulated processes and forms for determining both the loss of and the regained capacity. The capacity assessment process is specified in regulations. It's similar to the AGTA, including a rights explanation and a prior medical evaluation within a reasonable amount of time prior to activating the assessment. And again, that's to ensure that there's no temporary conditions that are affecting the person's ability to make their decisions. So again, the roles in a personal directive: you are the maker, you write the document and sign it and date it, and at that point, once it's been witnessed and dated, it becomes a legal document. The agent is the person or persons that you choose to make your decisions should you lose the capacity to be able to do it yourself. The capacity assessor is the person that can determine whether or not you are able to still make your own decisions. And service providers include medical staff, agencies, paid supports, anyone that works in the facility that provides medical service to you. Service providers are allowed to fill out a second part of the form if the physician is filling out the first part to determine your loss of capacity. The difference in a personal directive from a guardianship assessment is that the personal directive assumes that you have capacity when you write your document. The assessment is to determine if you have now lost that capacity. So it's a loss of capacity, not whether or not you have it in the first place. It's assumed, again, that the maker has capacity when the directive is written, and the personal directive only comes into effect when an assessment has been completed and determines that there has been a loss of capacity and you're no longer able to make your personal decisions. The assessment must be completed on the prescribed form, which is also available on our website. And the form is to determine if there is reason to believe that an individual is unable to conduct his or her personal affairs. Who determines capacity in a personal directive? It's a little bit different than a guardianship or trusteeship, although physicians and psychologists are still able to complete the assessments. In a personal directive, the difference is that you may name somebody in your directive that you'd like to determine your capacity. If you do that, they complete the first part of the assessment, and the physician or psychologist completes the second part. If you do not name somebody to determine your capacity, then a physician completes the first part, and a service provider can complete the second part. The declaration of incapacity, once it's completed, where is it kept? Again, a copy is given to the maker, so if your capacity has been assessed, you have a right to that assessment once it's completed. The agent or agents also get a copy of the assessment determining that you've lost your capacity, and a copy is generally kept on your file at the center that you're in, whether it's long-term care or acute care. Many medical areas in Alberta keep what's called a green sleeve on the patient chart, and the declarations of incapacity are often kept there alongside the personal directive. Can capacity be regained? If an agent or service provider that's working with you or sees you often notices that possibly you've improved from your situation where you were determined to have lost capacity, you can have another capacity to determine if you've regained that capacity. It would be the same process again. After the assessment is completed and it's determined that the maker has regained capacity, then the personal directive is no longer active. And the maker is then again able to control their own personal matters. This is the contact information for the Office of the Public Guardian and Trustee. If you have any questions about this presentation, there's also a lawyer referral service there if you have legal questions, and the Queen's printer where you can print copies of the Adult Guardianship and Trusteeship Act and the Personal Directives Act. So we'll take some questions now.
So the first question we have is, where would I find a capacity assessor?
Most of the facilities in Alberta, most of the long-term care centers and the hospitals will have assessors that have been trained and certified working in the facilities. If they do not, you can again look on that roster on the public website that gives you the names of capacity assessors by town that they will assess in. Some of them also list their specializations. Physicians and psychologists are all allowed to do them if they choose to, and many of them will also be listed on the public roster. Or you can phone the Office of the Public Guardian and Trustee and we can hook you up with that roster.
Our second question today is, what's the cost of an assessment?
Capacity assessments have a regulated fee under the Adult Guardianship and Trusteeship regulations. An assessor can charge $500 for co-decision making or guardianship or trusteeship assessment, or they can charge a maximum of $700 for guardianship and trusteeship assessment together. If the individual that's being assessed is in hospital or resides in a long-term care facility and those assessments are done under the under Alberta Health, then they would not charge a fee at that point.
Our third question today is who could conduct capacity assessments?
So as we said, physicians and psychologists are regulated to be able to complete assessments. They may choose to also undergo our 2-day workshops that help them develop their skills more and gain some educational credits. So they can do them if they choose to. Also, there are 4 regulated professions that can complete the training and also do the capacity assessments. Those 4 professions are registered social workers, registered occupational therapists, registered nurses, and registered psychiatric nurses.
Our next question is, what are the domains in capacity assessments?
So they're the same domains that would be in a guardianship order, and I'll try to name them all. One would be medical or healthcare decisions, where and with whom the person is to, where the person is to live and under what conditions, with whom they can live and associate, legal matters, education or training, employment, and social participation in social activities.
Our next question comes from a social worker, and she's wondering what is the process and where can she sign up for the 3-day course to become equipped to complete capacity assessments?
The courses are offered by us generally once or twice a year. It's myself that organizes and plans the courses, so you can get in touch with me. I also list the courses always on our website whenever I'm setting them up, so they will have the dates there. You can reach me at 780-638-3252 or at my email address is melanie.blackwell@gov.ab.ca.
And our last question today is there a universal assessment for determining capacity?
No, the model that we use was developed here in Edmonton at Covenant Health, and it's basically used province-wide, but every province has their own legislation and their own capacity assessment process. So there's no specific assessment that has to be done, but it has to be done on the regulated forms. That's the main thing. So I just wanted to thank you again for attending today's session and to remind you that today's webcast is part of the larger joint initiative by the Government of Alberta called the Human Services Learning Series. For more information about this series, check your emails for our regular updates or go to hslearningseries.ca. You can also follow us on Twitter at Alberta AB Human Services and with the hashtag OPGT. Thank you again for attending, and please continue to look for updates from Employment First, the FASD initiative, and the Alberta Brain Injury Initiative.